Okay, we're going to go ahead and get started. Thank you for joining us, everybody. Welcome. We have a few very distinguished panelists with us here today that I'm excited to hear from. But just to briefly introduce myself, my name is Rob DiBenedetto. I am a 3L at New York Law School. I am also the president of the New York Law School Dispute Resolution Team. We send competition teams around the country and sometimes abroad to various ADR competitions, whether it's negotiation, arbitration, or mediation. So I'm excited to hear from our panelists today. Before I introduce them, I do want to say that throughout this session, I will be giving out 3 code words that you will need in order to get your CLE credit. So be on the lookout for those. I will mention those periodically throughout. If you can't hear me or you're worried about spelling of the word or any questions, please direct those into the chat and I can put the words into the chat as well. But you will need those in order to receive your credit. And there will be 3 of them. So a brief introduction of our panelists. We'll be hearing first from Professor Kris Franklin, who is a well-known and well-respected professor here at New York Law School. She is also the founder and the co-faculty advisor of our dispute resolution team here. We will next be hearing from Jim Lawrence, who is joining us from Houston. Jim is the executive director of the Blakely Advocacy Institute and the executive director of the Dispute Resolution Center at University of Houston Law Center. And lastly, but of course not least, we have Sherlin Tung, who is joining us from Hong Kong very early in the morning. Sherlin is a partner at Withersworldwide in their international arbitration and litigation group. And she's also very involved in the VIS system, which runs several ADR competitions around the world. So I guess to get us started, I will direct some questions to Professor Franklin and open up the floor to her. And maybe just tell us a little bit about what these types of ADR competitions are, what your experience has been with them, and what type of educational opportunities they tend to provide for students.
Sure, thanks. I've seen competitions in all sorts of different areas. The ABA itself runs competitions in client interviewing and counseling, in negotiation, in mediation, in arbitration. There are private competitions that have sprung up all across the country, often in subject matters that students tend to be particularly interested in, but using the wide range of skills. Usually new competitions tend to center in things like arbitration or mediation or negotiation. I've seen fewer of the client interview and counseling competitions spring up, but it may be that that'll change over time. So I want to talk a little bit, primarily I want to talk about why I think competitions benefit students, but I do want to note that in my comments, I also want to talk a little bit about how they benefit other things. And I want to introduce at least a couple of caveats about what I think competitions do and don't do. So the first question is simply, why would we want to do any of this stuff? Well, the obvious answer for anybody who's ever practiced law is to realize that if people don't know how to talk to clients, if they don't know how to think through client problems, if they don't know how to negotiate, find me a business anywhere in the profession that doesn't involve some negotiation, even if only on your own behalf, let alone on clients' behalf. If law graduates don't know how to use these skills, aren't trained in these skills, they're not ready to serve as professional attorneys. That doesn't mean that we're going to graduate experts in them, but we should at least be graduating people who are introduced to them. But that doesn't answer the question, why competitions? It does answer the question, why these skills? Why these lawyering skills? Why do lawyers need to learn to work on client problems? But we could do that in classes. We could do that in other settings. What do competitions do? I think they do a couple of things that are really important. Students first came to me because they wanted to enter a competition and they asked me if I would help. Sure, that's fun. That's a great time. But this is simply me advising students voluntarily. It was a different move to go to my faculty and say, I think that this should actually be a co-curricular organization. Co-curricular meaning sort of student activity-ish. It's primarily student run. It functions as an organization that students are in charge of, but curricular in the sense that it is absolutely students get academic credit for this work, but also we absolutely are defining this as part of our educational program. So that meant I had to say to my faculty why we ought to do this thing. And I had to convince my faculty why we ought to do this thing. So what are the answers to that? One is competition obviously inspires motivation. Lawyers are by nature competitive people. We are more likely to engage and sort of throw ourselves into something when we're doing it. Yes, certainly when we're doing it for a grade, but it's not the only way to inspire it. But there's something more than that, which is, I think that there's an insight into how people think and how people learn that competitions show us. When we get enrolled, when we understand the position of a particular client and a particular problem in a particular way, I feel like I understand what I'm doing in a better, richer, deeper manner. I have seen students learn so much more about the law, about their client situations than they ever would have gotten if they were sort of doing an assignment in a class for a grade. And it's because they have to grapple with their position, their client's side, this particular forum. Is it a negotiation? Is it a mediation? To what extent do we do this in a common way? To what extent are there differences in the way you might frame the case, how you might work with the client, how you might work with opposing counsel if you're in, say, an arbitration setting versus in a private negotiation? There's something about these competitions that gets people excited about what they're doing, and excitement creates greater, broader, richer, deeper learning. Students in these competitions encounter areas of practice that they might never have thought of. They get professional feedback in, believe me, it feels very high stakes to students. They want to win these competitions every time. But frankly, in the real world, this is pretty low stakes, right? It's even actually lower stakes than for a grade. What it's doing is giving them an opportunity to exercise and learn their skills. In every school that I know that does this and routinely sends out teams, they practice repeatedly. They are mooting at every different time they practice. They should leave with a different set of experiences, a different set of encounters that enrich their understanding of what is possible in practice and guide them toward doing an ever better job in advocating for their clients' interests in whatever setting they're going to do. So let me talk briefly about a few other things. I actually think it helps all of us in practice when we work on these competitions. There is something about teaching that people who don't do it don't quite realize, which is you never learn anything better than when you have to teach it. The same thing is true for all of those people in practice, many of them very seasoned, very experienced judges, seasoned lawyers, coming in and having to judge competitions and explain to the student practitioners what they're seeing. It forces us to articulate to beginners that which we might know in our bones and do automatically, but articulating it is a different thing. You almost in that process teach yourself the stuff that you kind of already knew, but you didn't quite know you knew, because explaining it to a beginner requires putting it in its fundamental steps and thinking through what it is that they need to know. It also helps us get outside of our silos. It is amazing in the many years I've been doing this that when I watch judges from different practice settings, for example, come in and not be aware of what are common norms in the profession and what are norms that are unique to their area. For example, try watching a transactional lawyer and a prosecutor or criminal defense attorney judge negotiation. I guarantee you they will have very different ideas about what that negotiation ought to look like, because the norms in those professions about just sort of the style of how these things are undertaken are very different. And hearing that and seeing that what they're doing is, which parts are sort of siloed to different areas of the profession and which parts are not, is a really broad and general education that I think benefits all practitioners as well as the students who are hearing it. But I also think having these competitions does something in general for legal education. I have been saying to students for all the time I've been doing this, which at this point is like it's probably up to 15 years if you count the time before this was fully accredited as a co-curricular activity at New York Law School. I've been saying to students, talk about this in job interviews because it gets them the job. The minute they go in and say, this is what I've done, the first thing that happens is the interviewer says, wait, I wish they'd had that when I was in law school. There should be more of that. And then they want to talk about it. An interviewer talking to an interviewee about a subject that they're both passionate about is likely to make that be a successful interview, right? But in fact, there are ever more of it. And it's because we are defining that kind of training, helping our graduates understand that lawyers work with clients to solve problems as a central and core part of what legal education is and what it does. We are essentially saying out loud, these skills matter. This idea of what legal education is matters. Of course, students have to learn legal doctrine. And by the way, they learn legal doctrine a whole lot better when they're working with it in role for a real client than they ever learn it, no matter how much they study their outlines when they're learning it in a much more sort of deracinated class. But I do want to add one or two caveats. One is, I'm not convinced that all of these things are realistic. For example, in many settings, you would never do a negotiation with just lawyers in the room. If you're putting together some kind of business merger, the clients are likely to be there and be just as or more active than the lawyers. That's a thing that we tend to, since we're focusing on law students, we tend to pull out. Not every negotiation is non-zero sum. For example, I almost never see criminal plea deals done in competition. And the reason is because it's usually just a matter of yes or no. And that makes for a less rich and less interesting kind of negotiation project. And it doesn't work in a mediation setting, and it doesn't work in an arbitration setting. So there's some areas of the practice that we don't replicate as well. The last thing I would say is there is a small degree to which, because these are moot problems, they're not real problems, they're not real clients, there's a small degree to which I do think it is sometimes true that we overemphasize smoothness of speech, style, effective presentation, because we all secretly know, even though we don't concede it, that really the substance doesn't matter and wasn't created by the case, it was created by whoever drafted the problem. I try to get our students to prepare to deal with this as if it's as real as possible. I want them to think through as many possibilities as possible, but it's still true that everyone does know that it's fiction. And that makes it a little easier to overemphasize some things at the expense of others. Still, I think that these are small drawbacks. I think it's almost impossible to rule them out. And I think that every team I have ever seen compete comes back feeling like they learned a lot more from doing this than they ever would have learned in every setting. Every judge that I've ever spoken to while I've watched them do their work has said they not only found it enjoyable and were impressed by what they saw, but that they learned themselves, both from what they saw the participants do and from what they heard from the other judges. If that means we've done a good job for ourselves as lawyers, for our students, and for defining legal education more practically in the 21st century, I'm pretty happy with that.
Yeah, I find that very interesting. As a 3L, I've also graduated now to coaching a lot of our teams in the dispute resolution team, as opposed to competing myself. And I do feel that I've learned just as much coaching teams as I did when I was competing in competitions. So I do think that it's broader than just the educational opportunity for the competitors themselves. And I've definitely seen that in my practice so far too.
You're absolutely right. And it's funny, I should have included that, because it's all that kind of mentoring role. In my head, I think of that as still competing, because it is absolutely every bit of a part of understanding the problem. But it actually has the advantages that I described for competitors and the advantages that I described for practitioners who are judging, because it actually intersects both of those nicely. And it's common for students to move into that role when they've got a little bit of competition experience under their belt.
And I think one of the most interesting things that you said was that these competitions inspire motivation, and they inspire students to work hard likely to win. So I think that might be a good time to bring in Jim, because from what I understand, Jim won the first ever ICC mediation competition in Paris, which is a very large mediation competition, maybe the largest in the world. So from what I understand, Jim won the very first one, and he's coached very successful teams since then in the same competition. So Jim, maybe you can touch a little bit on what it's like to win a competition, the process of winning, and whether winning matters for the educational purposes.
Thanks, Rob, and thanks also to the New York Law School for putting this on and having me. So for the ICC competition, it was clearly life-changing for me. I'd never really experienced mediation in that context. And so does winning matter? Of course winning matters, right? And winning matters for every lawyer who walks down the street. So it's important, and it really does create some dynamics that I want to touch on for what Professor Franklin did in terms of students and professionals, with the idea that these competitions give students opportunities that are just incredibly challenging. So what they learn, what they pick up from these competitions that they don't get from class is that competitiveness. Now, in class, it's competitive for grade, but you're not going against other students from other schools. And I can tell you that, and Rob's going, yes, that's right. You know, your juices get flowing. You think, all right, it's time to really be focused. And so they get that sense of what it's really like to go out and work opposite another lawyer or lawyers. They're trying to do the same thing they're trying to do, which is zealously advocate for their clients. And I think that's really what this competition motivation boils down to. Another thing that it teaches them is teamwork. So all these competitions, you're paired with another student or sometimes students, depending on the makeup of the team. And so in law school, it's primarily a singular activity. Yes, you have study groups and you form those relationships that way. But when you're competing, it's you and one other or two other or three other of your classmates that you bond together over hours and hours and hours of preparation, of mooting, of studying, of planning, of thinking. And that type of teamwork is important when you go out into the legal world, because for the most part, you're going to have some opportunity to work with another lawyer on a case. You're not always going to be by yourself. In fact, if you go into a firm, you're most always going to work with someone else. So it's not like you're out there on your own. And that teamwork aspect, I think, is really critical to why students get a lot from these competitions. The last thing I would say especially about the ICC competition, is that there's a tremendous amount of cross-cultural consideration in that competition, because they bring 48, at this point, I think it's 48 schools from around the world to Paris to compete in this in the competition. And so you have not only your own competitiveness to deal with, but you also have to deal with other cultural issues that you may not be prepared for. And so teaching students how to deal with things, other cultures and things that they don't anticipate teaches flexibility, but it also teaches that sort of openness that you want to have, especially in the ADR process. The last thing I'd say for students is that the networking opportunities are incredible. And I know Sherlin will touch base about this and when it comes to the VizMoot, but when you're there with 48 other teams, that's, I don't know, what's that, 96 students minimum with professionals from all over the world. There's this, you get a sense of this larger community. And in the way our legal practice is evolving, if you're practicing law now in this current environment, the likelihood that you're going to have a case with a client or another lawyer that's from a different culture or country is pretty high. And so it really, really does put that to the forefront. And you can't create that in class. We run some exercises here at the University of Houston Law Center. We run some exercises where we try to simulate what different cultures might be like, but it's hard to get students to really buy into that in an authentic way. And so to go into an environment where you can put a team at a table with a mediator from Australia and a team from India and judges from Paris and Buenos Aires, it's an incredible opportunity for them to get a sense of what the global nature of the practice of law is like. And then I want to flip a little bit. Professor Franklin talked about the professionals who are involved. And so from the ICC's perspective, I also now judge in this competition, serve as a mediator. So I've gone from participant to coach to judge. And this competition, it's, as Rob said, I would say it's the premier international mediation competition in the world. They have over 100 professionals who come to Paris for a week on their own dime to participate in this competition. And that tells you the quality of the competition. And I think that's important. The when you're looking at competitions, quality is important because the judges have to be trained, they have to be knowledgeable, they have to really fit into the model that the competition puts forth. And the Viz does this, and I know that ICC does this. The judges and mediators have to fit the model. So they come from all over the world, these professionals on their own dime, to participate in this competition. And so what it does professionally is it gives you a chance to connect with people that you would never, ever get to connect with. Now, for example, Peter and I became friends through the ICC competition. And I have friends now in Australia, in Buenos Aires, and all over the world. I've met people that I've connected with. And you know, I'll have somebody call me from, I had somebody, I think 2 years ago, call me from Cincinnati, somebody I had met at the Viz. Said, hey, I'm looking for an arbitrator in a case. Do you know so-and-so? And I said, yes, I do. I know them very well. Well, what would you recommend them? I said, absolutely. So there's connections that happen with the professionals in these competitions that it's networking for students and it's networking for professionals. And I think that's a really, really critical piece of what makes these competitions so valuable. And I will touch a little bit on the realism aspect that Professor Franklin mentioned. It's difficult to necessarily simulate the reality of a situation. I know with the ICC competition for American teams, it's a little bit of a challenge because mediation internationally is more conference model focused. Here in the US, it's more caucus model. So teaching your students how to work in conference is an important part of the preparation process. And I think that teaching smoothness and coaching smoothness, I understand what she's saying, but I also think that we as professionals understand that persuasiveness comes not only from the facts that you have, but how you present them. And so putting both of those into a mixer and getting your students to really focus on those two aspects is crucial. And so, you know, I think that you look at competitions and you look at the ICC, you look at the Viz, you look at their historical longevity and the organizations that support these two competitions, and it tells you how well received they are and how respected they are. And I can say, you know, for me, winning the ICC competition was life-changing and transformative.
So Jim, just to back up a bit, for people who don't know the structure of what the ICC mediation competition looks like, I know you mentioned that you graduated to being a judge for the competition now, which serves as a mediator, I gathered also. But maybe you could just touch briefly on what the structure is like, because I know that the structure for mediation competitions varies a lot, and
Sure.
I know a lot of competitions try to figure out the best way to conduct a simulation of a mediation, whether it involves a student competing as a mediator and as a lawyer, an attorney for one of the clients, or both. So maybe you could just talk a little bit about the structure of how ICC accomplishes that and the struggles that you've had with how that structure works.
Sure. So the structure is you have, I'll just go sort of globally, 3 preliminary rounds at this point, and then you break to the semifinals, and then you break to the finals. And so each team, during the competition, you have a lawyer and a client. The requirements of the ICC are that at least the lawyer has to be a law student. So the client could be from a business school. So you don't necessarily have to have 2 law students together at the table. The mediators, the way they've structured it is that the mediators do not judge, they mediate. And what they've discovered over time is that mediating and evaluating are really hard to do at the same time. So what they do is they have a mediator, and all of their mediators are professional mediators. So you know when you go, you're going to get a mediator who knows what they are doing. The judges then, there's 2 judges per round in the preliminary rounds, and it goes to 3 for the semifinals, and then it goes to 5 for the final rounds. And those judges are sometimes mediators as well. And sometimes the judges can serve as mediators, but you don't judge when you're mediating. I want to make sure that's clear. And then the judges evaluate the teams with a well-developed score sheet. And the thing with the ICC competition is they have a very, very active rules committee, and they look every year at the rules and how they construct the competition and how can they make it better. And they continually change the way they administrate, score, evaluate, all those things. They're always looking at how to get better.
I think it's very interesting that you can bring also, say, a business school student to act as the client, which kind of goes back to what Professor Franklin was talking about, that in real world situations, oftentimes there will be non-lawyers in the room.
Right.
And I think that accomplishes that in this competition. I want to take a second to pause just to offer the first code word for the CLE. It's going to be Houston, Houston, Houston. So, Jim, you also mentioned that your career path was changed by the ICC competition. So maybe you could just touch a little bit on that and what that experience was like for you as a competitor and how that's kind of shaped what you've done afterwards.
Sure. Life-changing for me. First of all, I didn't know a lot about ADR when I signed up to compete. I will be perfectly honest. I signed up to compete because the competition was in Paris. And I thought, why not? And so from there, one of the prizes in the first year, one of the prizes for winning was you got an internship at the ICC. And so I spent a summer in Paris interning at the ICC, which was just an amazing experience. And how that shifted my career trajectory is that I became very ADR focused. I'm a qualified mediator, and I think that the idea that I went from a very narrow, wouldn't say narrow, a very short view, right? My surroundings were Houston and parts of Texas. And then suddenly my view changed to a much, much broader aspect of what was available in the world and how education, which I really wanted to be a part of, could shape the trajectory not only of a law student like myself, but of the legal profession.
Yeah, it sounds like a great opportunity. I think one of the other interesting things that you mentioned was that there's this cross-cultural component to ICC. So maybe I'll bring Sherlin into the conversation here too, because I know she'll be able to touch on that as well with the VIS competition, which also has that same cross-cultural component. So Sherlin, maybe you could touch on that and explain a little bit about the VIS competitions, what they're like, and then how they also relate to that cross-cultural component that Jim was mentioning.
Do you want me to touch first on the cross? Because if I explain all about the VISMIT, that may take us into another 15 or 10 minutes. Should I first touch on the cross-cultural aspect? What would you prefer?
Why don't you give us a background of what VIS is like first, and I'll make sure to bring us back to the cross-cultural thing.
Okay, since apparently you can cut me off in the middle. Also, just a side question. What happens if they spell the code word wrong, even though you spelled it out? I feel like this is something Hong Kong's going to start implementing with their CPD courses.
I am not sure, but I will put all of the words at the end in the chat just to make sure everybody has them.
Sorry, side note. Okay. Hi, everyone. Good morning. It is nice and bright and early here in Hong Kong, but not as bright and early as it could have been had you held this a couple weeks ago. Thank you, Daylight Savings. I'm here to kind of give you first an introduction on the VISMIT competitions. The VISMIT competitions are arguably, and I know that I'm going to get a lot of slack for this later on, the largest international law school competitions that are held worldwide. We at the VISMUTs don't think it's arguable, but if you talk to other people such as Jessup organizers, it's arguable because Jessup has various rounds worldwide. And therefore, if you combine all of those rounds, they are bigger than the VISMUT. But the reason why we say that the VISMUTs are the biggest competition is because the VISMUT really only has technically one real round, one in Vienna, one in Hong Kong. So they are sister competitions, and they've got a lot of rounds, small rounds that we call pre-moot competitions, which don't actually affect the actual competition itself. Now, what is the VISMUT? The William C. VISMUT competition was first started now 30 years ago. So that's right. We are in our 30th year in Vienna. We are in our 20th year in Hong Kong. And it was started 30 years ago by an amazing professor who at the time was Secretary General of UNSTRAL, Professor Eric Bergsten. Eric Bergsten was also a professor at Pace University, so he's American, but he had very close ties to the international community, particularly in his role as the Secretary General of UNCITRAL, which basically, I'm not even going to try to say the whole thing, and I should know this decades later, but UNCITRAL basically is responsible for a number of treaties and international contracts, organizations, and everything where they basically gather people together to produce uniform rules that would be followed by basically ratifying states. So the Vismut competition in itself is focused solely on international commercial arbitration. And every year it uses a different set of institutional rules, institutional arbitration rules that would be the basis of how the arbitration is proceeding. The substance of the Vismut, or the merits of the Vismut, every year concentrates on the CISG, which is the International Sale of Goods Act, which was produced and executed by UNCITRAL. Now, the Vismut competition 30 years ago started quite small. To my understanding, I think the very first year had 8 teams. It may be 16. Please don't fault me. I was not old enough to understand the Vismut at the time. But over the years, by now, before the pandemic hit in 2020, the last Vismut that was held in person was in 2019. And to my understanding, as of the 2019 in-person Vienna Vismut, there were close to 300 teams. I think it was 296 teams ultimately that had ended up physically going to Vienna to compete. So like I said, the Vienna competition is in its 30th year, and it was founded by Eric Bergsten. Now, the sister competition, which is the Vis East competition, of which I am the Vis East deputy director of, that was founded 10 years later by Ms. Louise Barrington. So she is known as the mother of the Vis East. And Louise basically one day went up to Eric because Louise had ventured out to Hong Kong and Asia a decade ago, actually now 3 decades ago. And she noticed that there was a very large market for international commercial disputes, that the parties were very, international business transactions were on the rise. You started to see an increase in relationships between the East and the West, but there was nothing really that could reflect this situation in the East. So Louise approached Eric and they had a discussion on how beneficial it would be for not only students, but also young professionals to have the sister Vis competition in Hong Kong. And so now 20 years ago, Louise Barrington established the Vis East competition, which uses the Vis Vienna problem and also contains almost the same exact rules. Just to be clear, they are 2 sets of competitions with 2 sets of rules, but our rules are based off of one another. You cannot compete at the same time as an oralist for both competitions, but you can be a competitor, basically a supporting team member for brief writing, researching. You can act as an oralist at one or the other, but basically you can take part in both competitions. You can only act as an oralist in one competition. The Vis East competition was founded and has had its home in Hong Kong for 20 years. And we're excited to say that it looks like it will continue to do so. Hong Kong is very supportive of the Vis East competition and international commercial trade law and international commercial arbitration. So that's kind of the background of the Vismuts. About cross-cultural benefits and what you can experience out of it. The Vismut competition, that is probably the one place in law school and also probably in your career as a professional where you will have the opportunity to meet various professionals and legal academics, students from jurisdictions all over the world. I know that the Vis East competition itself last year had teams participating from over 40 jurisdictions. And I know that Vienna had even more. So sorry, when I said in 2019, the last in-person Vienna Vismut had almost 300 teams. In Hong Kong, the last in-person Vismut, also in 2019, had 154 teams. Now, I know that sounds significantly less than Vienna, but Hong Kong had always had the commitment to actually cut off the number of participating teams to 100. Because for those of you who've actually been to Hong Kong, we're not as big here, and it's become near impossible to find venues that will fit all of the schools, as well as the arbitrators. And this is the same for Vienna. But nonetheless, the last year that we had it in person, we were able to fit 154. This year, we're actually aiming to have 100. I know Vienna is aiming, crossing their fingers to hopefully hit the 300 mark as well. But again, I mean, looking at the number of schools that are coming from jurisdictions worldwide, there's no other place where you will meet so many people from so many different places. And it's not only students that will come, professionals will join you in Vienna and they will join you in Hong Kong, because the week long of events, you not only have professionals who will sit in and act as arbitrators in the oral arguments. The Vismut competitions also organize concurrent networking, professional networking events, as well as social events. The Mood Alumni Association, which is the alumni association for the Vismuts, they organize a number of social events, which are pretty much infamous for people who have participated from day one. Everyone can tell you about the days where they met at the Moot Bar in Vienna, dancing on the tabletops in Mapitom. People from here in Hong Kong will tell you about all of the different bars that the MAA have organized Moot bars in, because in Hong Kong, bars come and go. But I know the stories from the old bars, the China Club or Dragon Eye, that are still around. And it's just a great place for people to mingle afterwards, where you literally will speak with students and arbitrators from worldwide.
So I've heard people walk away from the VIS competitions saying that it's taught them everything that they need to know about being a lawyer, and it provided a foundation for their approaches to problems as a practicing attorney. So maybe you can talk a little bit about educationally what VIS offers to students who are aspiring attorneys.
So I would also agree that one thing that we do have to remember, and I think as practitioners, we recognize it quite soon once we enter the real world. A moot world is definitely a different world. Nothing is ever going to be as perfect as a moot world. But I will also tell you this, and for the students that participate in the Vismuts, and you will hear it from the arbitrators you are preparing or arguing in front of. And after entering the real world, you will never have an associate, or you will never see a team that is as prepared as a Vismut team. Because the Vismut teams, basically, you are one family. You live and breathe Vismut. You live and breathe your teammates. You learn all about the arbitral rules that the institution that you are dealing with has, but it's not only the institution that you're facing, because the Vismut problem gives you basically 4 issues that you have to handle generally. Kind of goes, sometimes it's a little bit different, but generally it should be 2 issues on procedure, international arbitration procedure, which is actually something you don't learn in law school, whether it's in the US, in Europe, or Asia, unless you take a specific course on international arbitration. And I know, for example, in the US, yes, we're required to take Civ Pro, but we're definitely not required to take international arbitration. So the Vismut will be probably the first and best exposure that you will get in relation to the international arbitration procedural rules. The Vismut also introduces the CISG, which is an international treaty on the international sale of goods. Again, in the US curriculum, when you're in law school, sure, you're required to take contracts as a 1L, but you're not required to take international sale of goods. This is the same for other jurisdictions worldwide. So the Vismut is, again, probably the best place where you will learn how to deal with international contracts. And the reason why this is important, I do recognize that a significant number of participants from the Vismut, they don't end up in a career of 100% pure arbitration. I mean, I'm just going to be real, and I'm going to get in trouble from some of my colleagues. There is no practice that does 100% pure arbitration. But that's only because, and I'm sure litigators are going to know this very well, you oftentimes settle. You have pre-dispute negotiations. You've got post-dispute negotiations. So that's what these practice groups will often focus on. Now, the Vismut competition gives you that real-life experience of understanding not only how to work with other cultures, because that's exactly what international business transactions are. International arbitrations will always be between parties from different jurisdictions who also not only have a different legal structure, but also a different culture. So they approach negotiations differently. They approach settlements and everything differently. And this is what you can learn from the Vismut, because you meet these people from different jurisdictions. You can listen and talk to them about their laws. You can also listen and talk to them about how, their clients act. And that is one of the most realistic experiences that you will get from the Vismuts that you won't get even in real life. Because remember, in real life, once you're on a big team with a big arbitration or a big cross-border litigation matter, you really only get bits and pieces, and you guys work together as a team. But on the Vismut, you're working on the whole thing. You see everything from beginning to end. So I think the educational aspect of the Vismut is unique. It is something that is a once in a lifetime experience, and I think everyone should get it as a Moody. But I also think for those of us who, unfortunately, the ship has sailed to now be young and still be in law school and compete. Acting as an arbitrator also is a very good experience that you won't experience anywhere else. During my time at the ICC, and I worked at the ICC in both Hong Kong and New York, one thing that I would always hate to admit was the American lawyers were always the most aggressive lawyers on our cases because they approached arbitration as if they approached a litigation. And what the Vismut teaches you is arbitration really is different from litigation. It is not the same thing. Yes, you use similar skill sets. Yes, you use similar in the substantive law and everything is the same, but it's a lot more friendly. It's a lot more, it's a more amicable nature. And to come in when the ICC opened up its office Sikana in New York in 2014 now, wow, you could see the differences in the lawyers and you could automatically just guess what jurisdiction they were from looking at the way that they came in, their pleadings, their emails. But I can say that over the years, the Vismut has started to really disseminate how international arbitration is, and you start to see more and more people understand the nuances of arbitration versus litigation.
So I'm going to bring back our other two speakers as well here and open up the floor. By the way, if anyone has any questions that they'd like to pose to the speakers, feel free to put them in the chat and I will try to facilitate that conversation as best as I possibly can. But one theme that I've seen from all three of our speakers today so far is the idea of teamwork in these competitions and how the teamwork among students can help breed a learning experience or develop their skills. So Professor Franklin, maybe you can touch a little bit more on that and what you've seen in terms of educational opportunities and how students have really learned from working and collaborating with each other in preparation for a lot of these competitions.
Well, there's two parts of teamwork, and it's important. I think we've touched on both of them. One is the team of competitors who are working together. It is frequently true, as Jim mentioned, that most competitions end up having at least a pair of lawyers, or occasionally in some of the US competitions, there's particularly a few mediation competitions I've seen, there's a lawyer and a client. Sometimes we've had richer teams. We've had 3 or 4 members of the team, some of whom will be lawyers, some of whom will serve other roles. So there's that competition. They have to work together in an effective way. They have to think through themselves, like in a negotiation, do they want to both take co-equal roles, or do they want to emphasize different aspects of the case? Do they want to focus on and take the lead on parts of it? Some of that depends on whether it's a negotiation that is better done in a series of packages or that is better done in resolving issue by issue. Within an arbitration preparation, for example, there might be 4 people on the team, but they need to think through how does one student is writing an opening and one student is writing a closing. They better be consistent with one another. They better have a clear theory of how they want to operate. So they might not be active at the same time, but they need to put it together. So that's one aspect of teamwork, which is simply the team performing together. The other aspect is the team preparing the performance. And I think in many schools, that's much larger. It's not just the people who are going to compete. It's everybody that you can dragoon in. It's certainly, in our instance where we have a dispute resolution team, it's other members who might come in and moot, and ideally might moot differently and might prepare differently. Every time I do a moot if they've asked me not just to observe, but to participate, first thing I do is say to the coaches, what do these guys need to work on? How do you want me to play it? Because I can play it differently to work out different skills. Every person who comes in is going to have a different set of responses. Every time you can grab a professor, a dean, a practitioner, an alumnus to work with this team, you're building community, you're building input, and you're sort of increasing the plurality of voices that the competitors have to sort of consider and think through. And I think all of those things are useful. By the way, not incidentally, they're never bad networking opportunities for law students who are trying to make connections in the profession.
And I think there's almost another level to that of learning from the people you compete against. I think when you go to a competition like this, you see how other teams and other students approach the problem and how those students are taught by other professors at other schools. And in competitions like the ICC competition or VIS, these are students who are coming from not only other schools in the US, but other schools in other countries. So you're seeing completely different approaches to the problems, I would imagine, and different styles of negotiating or arbitrating. But Sherlin, I thought it was interesting. Maybe you could tell us a little bit more about what you think American lawyers have to learn about working with people from other legal experiences or other legal traditions.
I think I need to start again. I will also say this, during my time at the ICC and even now as private counsel, and even when I was in-house counsel, American lawyers always had the best submissions, and the writings and everything were always tip top, and the research and everything was impeccable. So please don't take it as a negative when I mentioned the American lawyers. The American lawyers just happened to be the most aggressive because they were coming in, the arbitration practitioners were basically litigation practitioners. And I think they were coming in from that litigation background, thinking, I mean, you know, in the US litigation system, we've got a number of things. We always have the document production, and hopefully we'll find that one piece of information that's going to, you know, blow up the entire case. This doesn't exist in Europe or Asia. I mean, they despise our document production idea. So I think what Americans can do when it comes to an international arbitration proceeding, and also just to be cognizant, there are situations where you do need to be very, very aggressive, because generally speaking, by the time you hit the arbitration, the parties have already gotten to a point where they're unable to settle and unable to reach an agreement. So they are pretty pissed at each other. But one thing I think for what we've seen in the communications is it's not a dispute between the lawyers, right? The dispute is between the parties, and the lawyers have been brought in to try to find a resolution, whether it's through arbitration or whether it's through subsequent settlements. So when approaching the other side, or when sending out communications, not only to the other side, but to the tribunal, it should be somewhat more of a friendly, collegiate environment, and maybe try not to push the other side, back them into a corner, because it really doesn't help when it comes to communications or when it comes to exchanges before you get to the actual hearing or the submissions.
Before I bring Jim in again really quickly here, I'm going to give the second code word, which is VIS, V-I-S, VIS, V-I-S. Very simple.
Rob, I'm wondering before, if you have a question for Jim, if I could just tack one thing onto what Sherlin just said, which is one of the things that we find most interesting in helping, particularly American teams, since those are the ones that we're helping prepare for these international competitions, is that we find that our law students are really bad at separating the idea that they can advocate as successfully as possible for their clients' positions without having to be particularly adversarial. That's a concept that law students in America seem to struggle with. They sort of equate a sort of fighting mode with aggressive advocacy for their client, and they fail to understand frequently that it is possible to do the very best job you can do for your client's objectives without needing to fight with the other side. And instead, it is possible to work with them successfully and yet still maintain your particular client's position and try to find a way to advocate for that as successfully as possible.
Jim, I'm curious to hear your thoughts on how you've prepared teams to deal with or compete against students of other legal traditions. I know you mentioned, I think you mentioned that you've used simulations to prepare students for different types of cultures that they might experience, but maybe you could tell us a little bit about those simulations or other methods that you found useful to help prepare students to compete against students of other countries.
Sure. I think the first thing that I would say, and it kind of addresses Francie's question in the chat, is that it's a great teaching moment. It's a great opportunity to talk about the concept of know your audience. Whether you're arbitrating or whether you're mediating in a competition, you're being judged, you have to know the cultural constraints of the people you're working with. And so I think in preparing them, part of and this goes to Professor Franklin's point, is teaching them, look, you don't have to be adversarial to be an advocate. That's not the point. And teaching them how to be a zealous advocate in a persuasive way, not an adversarial way. and how far and how much that can help them in every environment that they're going to be in. And so understanding, for example, the viz move, right? If you have arbitrators from different cultures, how do you construct your argument? How do you address them in a way that is as open to their responses as possible? And so when you think about then in the American system, which is what I primarily deal with, when you're going before a judge or a jury, it's the same idea. You have to know what your audience, you have to know your audience. And I think teaching students that process is a way to open the door to them understanding that there are, I'll use the cliche, there are a lot of ways to skin a cat. And you got to find those ways when you're teaching them.
And you mentioned that you use simulations of some sort to help prepare students for these competitions, right?
Right, and so we, the competitions, for example, the mediation competitions, the ICC, they provide simulations that you work with. And so in those simulations, some of them occasionally will have cultural considerations written into them. That's not very often. And so you really have to take it from a standpoint of, let's look at how different cultures might respond to this particular situation. But in teaching, there are simulations that you can get where you build in certain behavioral aspects of a simulated culture, so that the other party on the other side has to deal with that in a way that you're teaching them how to respond in an appropriate way. So those are the two different ways that we teach when we're preparing for a competition. If it's built into the problem, then you've got stuff to work with. If it's not built into the problem, then you have to take it from a much broader and actually more realistic viewpoint.
And I would like to bring it back just to the structure of these competitions. I know Jim and I talked about this briefly about how the ICC competition structures their mediation. And I know that a lot of the competitions, especially mediation competitions in the United States, have struggled or experimented with the way in which they structure these competitions. Professor Franklin, have you seen anything in developments of the way that a lot of these competitions are structured to take into account some of the things that you mentioned earlier, like including a non-lawyer in the negotiation, or any of these things that might bring in more practical, real-world experience into them? Have you seen developments or changes in the way that these things are structured at all?
It has become more common to include a client, and the places I've generally seen it have been mediation competitions. That said, I still don't think it's very common. Which is interesting because the ICC, that's absolutely part of the design, but it's less common in mediation competitions in particular. Have an interesting history in the United States, because one of the reasons that people started running mediation competitions was to introduce lawyers and law students to mediation in general. And so a lot of them, I don't want to describe them as the word that was coming to my mind was propaganda, and that's a little bit too strong and it sounds negative, but certainly an educational function of saying mediation has value, let's learn what it is. I have seen competitions that tried to introduce mediation in an educational way and then go ahead and do the competition, and sometimes include law students in the role as mediators. I feel a little mixed about that. I mean, mediation requires, there's something about practicing it that I think does encourage people to really think broadly about what it means. But mediation requires real expertise. It requires the real ability to listen and understand to what's being said, to make absolutely acutely good judgments about exactly what to say when and how to say it. And what, most importantly, what not to say and what's not your role. I do think the idea of teaching students to sort of introduce them to do that and try it out has some value, but it's also made me quite nervous when I've seen competitions doing that, because I think doing mediation poorly doesn't serve anyone well, and I'm not convinced that a brief introduction to a law student is a recipe for doing mediation well. that there's a field of expertise in there that we can't begin to touch. So I'm not sure what the right answer about that is. I do see some movement and changes. I'd like to see more. I would like to see more client interviewing counseling competitions, because I feel like client counseling is one of the key skills that every lawyer who works with clients ever needs to do. But it involves not simply interpersonal skills, but also genuine interest in developing facts. It requires knowing the law enough to know what questions to ask. It requires knowing when to listen, when to ask follow-up questions, and when to talk. I don't think there's enough very well-designed competitions in that area. And I think if we want to use competitions as a way of introducing and reinforcing what skills it is that lawyers need to have, there should be more in that area. And I just haven't seen enough.
Yeah, and I think one of the interesting things, especially about negotiation competitions, I would say, is that it takes a lot of inferences to understand what your client's objectives are. Is that it's not always clear exactly what your client's objectives are going into negotiation. And in the real world, you would go have a conversation, ideally, with your client and clarify whatever you need to clarify before you go into a negotiation. But when you get a fact pattern a few weeks before your negotiation that's not always completely clear on objectives, then you have to do a lot of inferring on what those client interests might be. So adding some sort of counseling or interviewing component to these types of competitions, I think would be an interesting addition. One of the other things I think has been really beneficial in these competitions for me is just the repetition of mooting. And I think that a lot of these skills are very personal in the sense that you can't just apply skills or strategies that you learn in a rigid manner. You have to find out what works for you and what styles work for you. So Jim, maybe you could talk about, in coaching teams, how you've encouraged people to use their own style of lawyering, but also apply certain principles and strategies that are commonly taught within, mediation, arbitration, or negotiation.
I think that is one of the hardest things about teaching and coaching, is that there are certain fundamental skills that you want students to get, and you want them to put those fundamental skills into their own style and for them to find their own voice. And I think, Rob, you mentioned repetition. I think that's the best way to do it. And as a coach and as a judge, I'll speak first as a coach. My job is to help you, Rob, as a competitor, is to find the voice that is the most authentic voice for you, not my voice. And then conversely, as a judge, I have to take what I think is appropriate out of the mix and evaluate that advocate on what they are doing, not what I think they should do, but what they're actually doing. And I think that's why judging is a really, really hard skill. It's tough to really be a good competition judge because you really have to step away from what I think and what I see and evaluate the student based on what the student is doing.
And so, Professor Franklin, you mentioned that there's basically a performative attribute to learning. I'd be curious to hear, Jim or Sherlin, what you think about that, as opposed to doing to learn, or as opposed to thinking about problems and the performative attribute that Professor Franklin seems to think is a big part of the learning process.
Let me pop in really quick from what I've seen. I've had the benefit of competing in this as an American with a US law school. And then now having arbitrated and done everything for the last decade plus. Yes, there's a performance aspect, but what we've seen, particularly in the Vismut, the performance aspect really comes from the Americans. I will happily say, however, personally, I don't think it's a performance aspect in the way that the Europeans and Asians have in the past kind of looked down upon us. There had always been comments of, oh, Americans, English is your first language, so you don't even have to get over the struggle of that. And then you can just take the words, twist it, and trick the tribunal. And that's why Americans do so well in oral advocacy, because they're able to basically perform. And, sure, there is a performance aspect in oral arguments, but I think that's what it is also as a lawyer, right? You've got good litigators because you've got litigators who have their facts straight, their law straight, and they're able to put it all together and put it before the judge or the clients in a negotiation. And what we have seen in the last decade is clearly this performance aspect is a great part of your legal profession. And we've seen schools on the rise. In particular, I've seen German schools, Asian schools, who are getting so much better in how they portray or perform their arguments. Their English hasn't necessarily gotten better. I mean, yes, their English is actually very good. It's impressive, the English that you hear from all of these speakers where English is their second, third, fourth language. But it's not really what they're basically construing together. It's how they're putting it forward, how they're putting the argument before the arbitrators. And so the performance aspect is there, but at the same time, arbitrators aren't stupid. Your arbitrators are going to sit there and they're listening to what you're saying. So I don't care how great you are, how great your speech is. If your analysis doesn't make sense, the arbitrator is going to catch you on it. And that's actually the benefit, one of the huge benefits of the Vismoot. You're going to get one arbitrator in your panel from a civil law jurisdiction, one arbitrator from your panel from a common law jurisdiction, and the third arbitrator generally is either an academic or a coach, somebody who knows the problem like the back of their hands. So you can't actually circumvent the problem itself and just perform.
And would you say that there's a performative aspect to the learning process too for the students in that? Or is obviously there's a performative aspect in how you display your case to an arbitrator or to a judge. But in terms of learning for the students, do you think that's a crucial part of the learning process as well?
I'm happy to jump in on that one quickly, and I see Sherlin's got her microphone off as well. So for me, the neurology of speaking something is so different than the neurology created by thinking something. And so you can think about a problem all day long, but when you start actually articulating the problem, articulating your support, I think that's where the real learning happens. So that connection, and that's why I'm such a strong believer in advocacy skills training for students, is because you can sit in this, a contracts class and you can think about contracts and you can write about contracts. But when you start talking about contracts and writing contracts, that's a whole different ballgame. And so I think that's part of what these competitions really bring together is the thinking about it and the doing it, putting it together in a way that really helps the learning aspect.
And Professor Franklin, I wonder if you have anything to add, because I know Professor Franklin had started a family law. I don't want to get too far away from ADR here, but she had started a family law and practice course at New York Law School, which is very performative in the sense that it's in practice and it includes a lot of simulations and practical experience for the students. So Professor Franklin, I wonder what you have to say about that and the role it plays in the learning process for students.
Yeah, I should be clear for people, for at least the Americans who are watching this, there are lots of clinics in law schools. There are lots of opportunities to do experiential learning, and there are far more than when many of us went to law school simply because our regulators require it. The course that Rob is referring to actually isn't one. It does actually earn experiential learning credit, but what it's actually intended to do is be a standard doctrinal survey of introduction to family law, taught through simulations, taught through client work, and introducing as many aspects as possible. Why? Because I believe that that's what helps students really, really master the material. I entirely would co-sign what Jim says, which is like, when you say it out loud, you realize what you actually think. Sometimes mid-sentence, and then you got to figure out where you're going to go with it. But there's simply something about doing that changes and enriches our understanding. When I do in fact teach contracts, so I think it's funny that we've used that as an example, but when I teach contracts, one of the things that my students are about to do in a couple of weeks is negotiate contract language. Now, I'd love for them to learn a little bit of negotiation skills. I'd love for them to learn a little bit contract drafting skills. Honestly, that's not why I do it. The reason I do it is because when I have them do that, they will think about and understand how the contract is built in a way that I simply couldn't get them to do if I didn't have them doing that kind of work. So to me, it's a bonus if they're also developing the kind of professional skills and interactive work that is going to make them better as practitioners. if they want to learn the law itself, they have to engage with it in a different way than simply sitting in a room and reading about it or writing an outline about it. I think they learn it better.
Yeah, and I think that Professor Franklin, you mentioned earlier too that a lot of competitions touch on different areas of law, and there are different norms in how practitioners negotiate in different areas of law. I'm curious, Jim, does the ICC competition cover what types of issues do students mediate in the ICC mediation competition? Is it different issues every year, or is it similar issues? Do they get a broad range of legal issues, or is it kind of narrow?
It's different every year. They have a very regimented and thorough problem writing process. So they ask practitioners to submit problem scenarios that they vet through a committee, and they look for ways to make them always interesting and always dynamic. And so the topics range are wide-ranging topics. Not all of the problems, I would say, are created equal. I think sometimes you run into a problem that's not that great, but that's part of what you teach students is, you think that you have a bad case, but sometimes you get difficult facts that you have to deal with. And so everything that they create, you can turn into a teaching moment for students to say, we have what we have, and we got to figure out how to make that work. And so the legal aspect, and this is what I would say about the mediation competition that's different from the Viz, is that in a mediation competition, if you're really focused in on the law, you're going down the wrong path. Because if you're going to argue about the law, you're going to be in court, because that's why you're there, right? You can't agree on what the law says. So, so getting them to understand what the law is, how to use it as part of your persuasive presentation is important, but focusing on it, really learning the detail about it, that's not part of the mediation competition.
And I do, before we finish up, want to get to a couple of the questions in the chat. One of them is about literature and what types of books are recommended for students to read on this topic, but then also I think getting at what type of books address, if any, address the educational process during these competitions for students. And I'll open it up to any three of you if anyone has any input.
For the Vismood competition in particular, I know that there was a publication done by Louise Barrington and a number of Vismood old school arbitrators, where they published what they would believe the award would have been like from the Vismood problems. Now, this doesn't go necessarily to the educational aspect of the Vismood or how you can train yourself, but I think it's a good book to read, because then you can read the problems that are available online, and you can see, the submissions from the winning briefs from the schools that are also online. And then you can see what a real arbitrator probably would have decided based on the arguments of the parties. I do recall that there are also books out there on mooting, again, in particular to Vismooding. Shame on me, I don't know what they are, but I would suggest go on the MAA.net website, go on the Vinda-Boner Journal, and there will be many publications that talk about the Vismood competition, from practical experiences on how you can prepare, and also the substantive topics themselves.
And Professor Phillips just mentioned me, so sorry, I don't want to cut you off, Jim, but Professor Phillips just messaged me as well and says that the ICC, this might have been what you were about to say, but the ICC sells a book of its past problems that they've used in their competition, and it's on the ICC website.
I was actually going to say what I recommend for students in general advocacy, but more importantly, negotiation and mediation competitions. And this is what we have our students use in preparing for the ICC. The first one is the classic Getting to Yes. That's one book that every negotiation student should read at some point. Another book that I recommend our students read is Thinking Fast and Slow. And then the last book that I recommend they read is Blink. So those are three suggestions that I have in terms of expanding the the way you think about negotiation and mediation and even advocacy in general.
And then I'll try to move to one more question from the chat, and that's, would more engagement in old school methods like collegiate debate clubs advance skills in building focus, drawing and clarifying distinctions, and team building that we've all discussed so far? I'll open it up to anyone that wants to answer. I would say I've experienced with our own students on our team that those who have participated in debate clubs tend to have a leg up on effective communication and just understanding and public speaking, just because they've done it before. But I will open that up to anyone else who wants to answer
I
that.
think there's two things that debate does that are enormously helpful to prepare for law school. One is simply get people confident and comfortable at speaking and learn how to speak succinctly and directly and clearly. They often have people who've done debate, they often have a better sense of how they come across. And that's one of the things we're often working with students on, is sort of enough self-awareness to figure out what's the right style for them, that in a way that is responsive to how audiences receive them, which may not be precisely how the students perceive themselves. I think a lot of debaters have already sort of been through that. They also come with the ability to frame legal arguments. I realize that debate is not necessarily legal arguments, but it is so similar to how we put together arguments. The one thing that debate does not do that can be a big issue is actually debate tends not to, even when people debate in teams, they usually debate with, I'm on a team and with Rob and I represent this issue and Rob represents that issue, which means we have to work in tandem, but we don't necessarily have to work together in the way that a pair would have to work together as co-counsel in a mediation, for example. So it works much better if you're preparing for an arbitration where we have to be on the same page, but we don't necessarily perform at the same time. The other thing it does not do at all is have students think through carefully, how do you solve problems that clients are facing? So it's great on the argument side. It's not necessarily as good on the really thinking through what is an effective way of approaching this particular problem, which matters particularly in mediation and negotiation competitions. So it has a lot of advantages, but not automatically.
Okay, I think that just about wraps it up for today. I know we're a few minutes early, but unless anybody else has anything to add, I think we are good to go. Thank you so much, Kris, Jim, and Sherlin, for joining us. I hope this was a beneficial conversation for everybody. I know I learned a lot about the different competitions that VIS and ICC offer, and I hope to continue a career also in ADR. So this is very beneficial. Thank you so much for joining us, everybody.
Thank you, Rob.
Rob, you need to give the third code word.
Sorry, yes, the third code word is negotiation. Another easy one, negotiation. I won't spell that one out. All right, thank you so much, everybody.
Thank you,
Bye.
guys.
Thank you all. Thank you so much.
Bye.